Okay. Peace to the viewers. Peace to the viewers. So last class we started with the French Protectorate, right? We went over a series of responses between the French Republic and United States of America, and them trying to discuss what to do with the Moorish subjects and the proteges. So just for a few seconds, we're going to rehash what we talked about, revamp on what we talked about. We discussed that Moorish subjects and proteges are under the jurisdiction of the United States of America, right? We learned that American nationals are also deemed as so-called Moorish subjects and proteges. All United States citizens are deemed Moorish subjects and, or excuse me, Moorish subjects and proteges are deemed as U.S. citizens, right? Even though there's a difference, being that they're all under the jurisdiction of the United States and they're operating one, they're putting everybody under one umbrella, United States citizens, regardless of what you trying to do, right? If you don't have your own Moroccan state government, then you're stateless and therefore under somebody else's state, right? So we'll start off um, halfway through these documents, and um, we'll start halfway through these documents and start from not exactly where we left off, but based off of this understanding that we have. So this is the French ambassador to the Secretary of State. It reads, Mr. Secretary of State, referring to the oral communications by which I made known to the Department of State the views of my government in respect to the remarks contained in Your Excellency's note of February 13th last about Morocco, I have the honor to, in compliance with the instructions I have received, to remind you of the high value we should attach to the United States government relinquishing, together with its consular courts, its extraterritorial privileges in the French zone of the Sharifian Empire. Your Excellency's note above mentioned held out the prospect that the United States would accede, I believe you read this, but accede to our request and record its accession in due and proper form, but pointed out a certain number of topics as to which
That's
favorable
my button. I
assurances.
don't hear anything.
Huh? What'd you say?
I don't hear anything. It's like going in and out.
You said
I
you
don't know
can't
if it's
hear
me.
anything?
Now, okay.
I know personally, I hear you fine. Might be a personal
Yeah,
technical issue.
that's what I'm thinking. Let me fix
I
it.
can't really understand y'all. I'm not sure if y'all can understand me.
I understand you clearly. I can hear you well.
I can hear you as well.
I hear everyone now.
Hold on, there's something wrong with my end, my connection or something. Cause everybody coming off choppy. Just a second. Is that better? Can you guys hear me?
Islam.
Okay.
Islam.
Okay. Not sure what that was about. But let's continue with the reading. If everybody else can't hear me, let me know. Just cut me off and let me know. So it goes to read, as to the matter of, well, let's discuss what we read so far. It was talking about the extraterritorial jurisdiction, the extraterritorial privileges in the French zone of the Sharifian Empire that the United States was having occupation over. So they was controlling the French, they was controlling Moors in the French zone, Sharifian Empire, right? So basically, Moors in the French zones are supposed to be under the protection of the French government. Moor subjects in general are supposed to be under protection of the French government. But the United States was in the way, saying, no, we are basically the ones deciding what to do with these people or persons, right? Who want to be seen as people or people who are acting like persons. So it goes to say, as to the matter of form, my government wishes me to submit to your excellency the enclosed draft of declaration, which it is opinion fits the situation that is to be cleared. I am told that the declaration has already been signed by the Russian and Spanish governments and that other adhesions are forthcoming. As to the several points mentioned in your excellency's note, I may ask to have already done by word of mouth, assure you that the government of the Republic is quite ready to settle in most friendly spirit the questions of interest in the United States of Morocco that may still be pending. Among these, that the proteges naturally ceases, to be of any practical importance of the powers that agree to recognize our new courts, the tertib tax being, besides, already paid by the foreigners. As to the right of aliens to own real estate, i.e. the colonists that own this land, it has not been restricted, by any Sharifian regulations. So basically, no government, no Sharifian or Moroccan government has not came in to regulate their standpoint with this land. All that has been done was to take a few urgent measures having relation to strategy or prompted by the necessity of checking speculation in land intended for public use. So they basically saying all that has been done for urgent measures, right? Having relation to a strategy. What does this mean? The United Nations, these letters, all of what France has been doing. When they took them to court in 1952, of course, that's later on compared to this document. But they're saying all that has been done was to take certain measures for a strategy that prompted Moors, to check this speculation for public use, right? So the United States of America is telling everybody this is the United States of America, this whole landmass. Using that's how they publicly using this. They're publicly using that platform to exercise all types of things on this landmass, right? So it says the complaint of the Vacuum Oil Company against the customs treatment according to its products had not been brought by the party concerned or the representatives of that country to the notice of my government, which deems its duty in this respect to recall the treaties and force guarantee equal fiscal treatment to all the powers, and that they may be sure that nothing will be overlooked to let their nationals enjoy full benefit of those advantages. So no Moorish government, no representative of Moorish government of that country or state. Remember, states are countries. So no Moorish government has notified them what they're saying as far as how the nationals can exercise these treaties. It goes to say, my government indulges the hope that under the conditions I have just brought to mind, and in view of its firm intention, and examine a settle examine and settle in an entirely friendly way the few questions yet unsettled which American citizens are interested. Your Excellency will kindly coincide in the views I have just had in the honor to submit to you. Your acceptance of these propositions will be particularly gratifying to the government of the Republic, which would take it as fresh evidence of the traditional friendship existing between our two countries. Uh, so the secretary responds to the French ambassador by saying, I have the honor to inform you, Your Excellency, that the department is in receipt of a telegram from the American charge d'affaires at Tangier, stating that the French diplomatic agent in that city, in the name of the French resident general, had requested of him a memorandum of pending and unsettled claims, understanding that this government would not be favorably inclined in recognizing the French protectorate until the cases were satisfactorily disposed of. The American legation at Tangier has been instructed to submit the proper French authorities a memorandum of all pending American claims in Morocco, and I beg to assure Your Excellency that a satisfactory solution of these cases will greatly aid the government in replying to your note of January 8th, 1913, containing the request of your government for the formal recognition of the protectorate in Morocco. So far, what the Secretary of State is saying is that they cannot recognize this French protectorate until things are disposed of as was stated before. They go on to say that basically they're building up to say that, which we'll get into later, that they notice this French protectorate and these cases must be disposed, but they still put up a fight because why are not more subjects under French protection, right? So they're saying they recognize what must be done in the measurements. They go on to say again that containing the request of the government for the formal recognition of the French Republic in Morocco. So again, they're working as a corporation and they're not operating as the de jure United States of America, right? So for them to send requests, i.e., etc., right, they would actually have to be in those seats of government, right? So there's many kinks and twists as to how they're trying to get them to do something, how France is trying to get United States of America or United States to do something, right? Because they say they recognize something, et cetera, et cetera. But as we further read, how can a government recognize something if they're not in that seat of government, right? So this is what makes right now the so-called term America for sale valid. The Moroccan government, the Moroccan Empire fell, right? And the United States of America is vacant. Therefore, nobody's actually governing this land. In which that's why more state governments can be so easily recognized or acknowledged as a state government. Because if all you have is a corporation at most calling themselves a state, then by law, nobody is truly running this land. So the French ambassador states, my government, to which I did not fail to forward the contents of Your Excellency's note of February 13th and April 30th last, about the doing away with the extraterritorial rights in the French zone of Morocco, and about certain claims of American citizens, has just affirmed to me that it had promptly taken steps to bring about, under the most equitable conditions, a settlement of those claims. In regards to one of them, that of the Vacuum Oil Company, my government, which had never heard of it, wrote to Morocco to inquire about the grievances the grievances the concern might have to state as to the customs treatment it receives. General Thuety accordingly called upon the agent and of the company for explanations. The answer was that he had not the slightest ground for complaint against the customs authorities. So basically, they're trying to get clarity on who owns what, and they said the owner had not the slightest bit complaint against the customs authorities, against what France had to say, right? So we got these companies and corporations in the way. In France, they trying to check things like, you know, all these corporations, it seems to be running things. When we cross the T's and dot the I's, well, there seems to be no problem. So what's the problem, United States? Right? As for the other claims, the instructions sent by your excellencies to the representative of the United States at Tangier have no doubt brought to your knowledge with all the needful explanations that the facts from which those claims may have risen. I beg leave in your connection to refer to the note that I have honor to address to your excellencies on the 22nd ultimo April, in which, while answering the main points mentioned in your note in February 13th, I laid stress on the importance attached to my government to the government of the United States, earliest possible accession to the request I had laid before you. I'm informed by the government that Russia, Spain, and Norway have already renounced their extraterritorial rights by signing a declaration like that enclosed in my above mentioned note. Other accessions are momentarily expected. So Russia, Spain, and Norway already have renounced their extraterritorial rights or jurisdiction in Morocco, leaving the United States having to do so, right? Uh, uh, and so basically what's going on is that when we talking about acceding land and treaties, et cetera, we have to make these declarations. Remember, it says how Spain, Norway, and Russia all made declarations talking about how they're getting rid of their extraterritorial jurisdiction in Morocco. So these are just declarations, right? Then there's later treaties, right? So the United States is saying, look, so far we all heard about the relinquishing of jurisdiction in Morocco by the United States, right? So far they're saying all these other places relinquish jurisdiction, they're not there, right? So the United States, what you must do is relinquish jurisdiction. What kind of jurisdiction? Consular court jurisdiction, right? So it's a specific type of jurisdiction. They still have a limited jurisdiction, but the jurisdiction that they were forced to relinquish was consular court jurisdiction. So, and we talk about criminal and civil affairs at that point. Okay, we're not talking about what state you belong to or nationality in general. That's a different topic because you're still subjugated at that point. Just because it's consular courts, jurisdiction has been removed doesn't mean you have a government. You can enforce legal laws and all that type of stuff because the first thing is you got to establish a state government to do any of that, right? So consular court isn't the whole thing. So it goes to say, the French charge the affairs to the Secretary of State. In the course of the negotiations for the suppression of consular courts and the extinction of extraterritorial rights in the French zone of the Sharifian Empire, it was occasionally objected to the representative of the Republic that it was not possible for the powers to take any further responsibility in the fate of the Moorish proteges. So it was not possible for the powers to take any further responsibility for the Moorish protege. Now, you see how it says Moorish protege, just so we can get more clear on who proteges are. It's Moorish subjects and Moorish proteges, right? So that they're both referred to one and the same. So due to you being subjugated, you now have protection by another government. So they're one and the same. So it says there would seem to be some foundation for that feeling. In fact, under the provisions of Article 12 in the Franco-German Treaty, or Franco-German Agreement of November 4th, 1911, whose full scope is given in an explanatory letter, the government of the Republic will certainly have the right after the discontinuance of the consular courts to ask that protection be done away with. The strict legal effect of this would be to place under native jurisdiction the proteges who, under the present system, are enjoying consular jurisdiction. But with the view of obviating the hardships that might thereby be brought upon, the more subjects thus derive of protection. The government of the Republic is ready to declare them to be, as long as they live under the jurisdiction of the French courts set up in the protectorate. So they're saying more subjects are always going to be protected by French as long as that's set up in the treaty. This would place them in this respect on the equal footing with the person subject to the jurisdiction of a former protecting power and not with its natives. Okay, so they're trying to get protection set up in the right hands. They're saying there's no way the United States can protect the Moorish subjects, and they don't even have a certain treaty that aligns with modern day time to do so. Because if they truly tried to protect Moorish subjects, they would just simply follow the Moorish treaties that we agree upon. It goes to say, my government authorizes me to take its intentions as to this known to the federal government, being convinced that they are likely to remove any apprehension concerning its proteges, if, after availing its of the rights conferred upon to the existing provisions, the government of the Republic should procure the abolition. I avail myself of this opportunity to enclose 3 copies of Louis Renault's preface to the codes and laws in force of the French protectorate in Morocco, which brings forth the value and importance of the legislative work of the protector, showing as it does the guarantees extended to all foreigners in Morocco. The paper ought to expedite adhesion to a new system out of the part of few powers that have not yet relinquished the exercise of consular jurisdiction. Be pleased. So again, this is 1914, right? In which consular jurisdiction was not yet relinquished until the 1950s. Okay, 1956. So keep that in mind. We're talking about the relinquishment of consular jurisdiction. This is 1914. Okay, several decades before the 50s. So the French, their affairs to the Secretary of State. By a letter dated February 13th. Let's kind of fast forward here. Let's go down to it says, with the exception of 2 clearly defined cases, a vacuum oil company and the Benatul case, which will be fully explained herein after. The federal government formulates, but does not specify, reservations or demands of a purely general character against the protectorate government. So they're talking about, all these companies, they don't specify their plans, their intentions, etc., their alignments with this protectorate. They're not discussing anything with France. We don't see how they are the ones in charge of anything or in the way of anything. So they calling stuff out. There is no question about the federal government being, as much as any other government, other, warranted in watching over the economic rights and interests of Morocco, which, as put by Mr. Bassett Moore, are safeguarded by the treaties concluded between the foreign powers and the Sharifian Empire. But it's equally true that the protectorate government is bent on respecting to the fullest extent, in favor of Americans as well as other foreign citizens or subjects, the principle of economic equality. So right quick, it says, not only does it plan on respecting to a full extent the Americans, right, in favor for the Americans, but also foreign citizens or subjects. So basically, by taking care of the foreign citizens or subjects, more subjects, right, is to then work in alignment with the treaty that the Americans set up with us. So it might not be in favor for them in reality, but at least by law, yes, because that's the treaty they made, right? So if the United States of America agrees to basically follow the treaty, they would agree to put us in our right status, which would essentially, be the cause for their downfall. So this is counterintelligence going on right here, right? It says the principle being once more evoked, the reservations or claims put forth by the federal government are so general in their character that from the fact that the importance of American interests and the number of persons lying under American jurisdiction appear to be out of proportion to the set reservations and objections offered, the question arises whether Mr. Bassett Moore's letter of February 13, 1914, is not aiming, after all while the federal government expresses itself in favor of the reforms, to reopen the question of the very principle of the protection of the protectorate regulation powers. As a matter of fact, it does not seem possible to maintain the protests that have been made against the protector government upon careful examination of every one of the questions presented. As regards to the contemplated martial law in cases of contraband of arms, the matter having been settled by dropping the subject need not to be brought up anew. The federal government statement about protection leads one to believe that the meaning and scope of the protectorate's intention have been misunderstood. So they're saying that, maybe your federal government, because y'all not complying right, maybe y'all just got it misunderstood. Maybe that's not why y'all complying how y'all supposed to. Indeed, it never has heretofore our intention to do away with protection, but we meant merely to stop its improper use through revision of the list jointly with the delegate of every legation concerned. Provision, furthermore, for such revision was made in the Franco-German Treaty, to which the government of the United States gave its adhesion. It is important, however, to take notice of Mr. Bassett Moore's assertion that the choice of the American protégés rests ultimately with the government of the United States. So that's what they said, right? The choice of the American protégés, i.e., the Moorish subjects and Moorish protégés, rests ultimately upon the government of the United States. Basically, saying Moors got to go to the United States, right? He put that in quotations, right? So they said, for the right to choose can only be expressed within the limits wherein it conforms to the treaties of the provisions with the Moxon may remind the powers concerned in order to obtain the return or enforcement to those conventions. So everything that we have to do is in the treaties, as they say. And they're saying the Moxon, which is the Moorish government, right? The Moxon has to remind the powers. in order to return to the enforcement of those conventions. So in order to return to our state of when we was rocking with the treaties, enforcing treaties, all that type of stuff, the Moxon or Moorish government has to remind the powers in the proper way. By that I mean to follow instructions or treaty. So real quick, does anybody have anything to say? Any questions, comments, concerns before we continue? Just a second, yeah. Okay, so it goes to say, if the powers would forego, in principle, their consular jurisdiction, we might, per contra, take up such enforcement in as liberals as spirit as possible, and to the end, come back to a bilateral vision as provided in its Franco-German treaty. The remarks offered in regard to the original circular of November 1st, 1912, laying down rules for the purchase of land, appear to have been prompted by an incomplete study of the subject on the part of Washington government. On the one hand, the consent of government referred to in Article 11 of the Madrid Convention, in Article 60 of the Act of Algeciras, and again mentioned in the regulations of November 1st, 1912, does not, of course, apply to any of those parts where consent is requisite. That is to say, without the kilometer zone around the ports and the 2-kilometer zone allotted to Azamor. On the other hand, the circular of November 1st, 1912 cannot apply to the Tangier territory specifically referred in the American memorandum, since Tangier and its purlieus do not come under the regulations decreed in the protectorate. As to the habeas or government land, the Geesh lands, well, actually, we can skip forward a bit. Next paragraph. In answer to the fault found with servitude zones, we are justified in holding that the purchases of land are permitted at the Act of Algeciras, Article 6, subject to the obligation. Okay. It says, let's see, permitted by the Act of Algeciras, Article 60, subject to the obligation placed on the purchaser to conform to the laws and usages of the country. Now, the Sharifian decrees creating zones of military servitude are precisely to be numbered among local laws, as the aforesaid Act of Algeciras could not presume to prevent on every subject whatsoever, laws and usages, or include in that phrase only those that existed in 1906. So skipping down to the fifth point, as regards to Article 63 of the Act of Algeciras, the protector government never showed any intention to evade its operation, and still more unfounded is the assertion of the Sultan gave notice that the diplomatic courts of measures aimed at the recovery of property of the class referred to the aforesaid article. Such a notice never was served. The only measures taken had for their sole object the prevention for the future of the wrong settlement of which for the past must be effected in accordance with the procedure directed of the Act of Algeciras. So they're basically saying, as far as the land in the United States, pretty much taking over the land unlawfully, Everything is in the active adjectives as far as what we must do to get it back. It's what they're saying so far. Point 6, it says, as for the customs, grievances formulated by the American government, the protector government is quite ready to give them full consideration when they are specified. So they're saying that for France, right, who was one of the big five in the United Nations, France is ready to give them full consideration on what to do, right? So they basically ready for the United States to get out of here as soon as they can further tell them, enforce that. So this is what the United Nations. France has a big part in the United Nations. This lets you know right now the type of support, right, that we have with our counterintelligence. So, because I remember, because of this case, because of this France versus United States of America case, this we're gonna later read in later videos. This is not the case, but in that case, because France pressed the United States of America, the United Nations made United States of America relinquish that jurisdiction. And that was only because France took them to court and the United Nations made them, right? So France is ready to give them full consideration, full instructions, right? On basically how to get back to Europe. So it goes to say, the only case presented in the memorandum of February 13th has been investigated at Casablanca by our consul there. He reports that the agent of the vacuum oil company at Casablanca told him he had not the slightest ground for complaint against the customs authorities, but the memorandum of the charge d'affaires of the United States at Tangier, hereinafter discussed, having explained that the difficulties under consideration had occurred at Safi and not at Casablanca. General Louis referred the question to the office of the comptroller of the debt of Tangier, which will furnish all the data with which the settlement of the customs difficulty may be taken up at the earliest possible date. Okay, and a few more pages here. It goes to say, as regards the American claim against the MOX, the government of the United States may be assured that they will be examined in the same light of the claims of persons under foreign jurisdiction. Those already passed upon the Commission of 1910 will be paid in total to the beneficiaries of the funds in the loan that had just been voted. 8. As of the Benatul case, our agency at Tangier gives me the following information confirmed by Mr. Phillip, our consul at Tangier. It agrees with the information supplied by the Washington government. It goes to say, let's read it anyway. Jacob Benatul, an American semissar, having obtained a judgment from the SRAB about 8 years ago in a real estate suit against several foreigners, of whom one, Mr. Fries, was French, did not choose to comply to our consular court for a ex-quarter of the Cadi's judgment. The legation of France and America tried but failed to bring about a friendly settlement of the Cadi's award by a payment by Mr. Fries, the loser of a indemnity to be determined by umpires, but our fellow citizen, arguing that the judgment against him had been obtained by fraud, would not listen to any settlement. Inasmuch, however, as the land in dispute lies with the Tangier zone, the American government cannot condition the relinquishment of extraterritorial rights upon settlement in this case, which by reason of its suits, does not lie under the jurisdiction of the protectorate authorities. So the United States of America can't do nothing about them, their rights being relinquished, right? That extraterritorial jurisdiction being relinquished, the United States cannot do anything about it because it's not in their treaties to even do that, to be moving with such sovereignty so forth. It says, in order to arrive at the most precise knowledge, if possible, of what is asked of us, our agency at Tangier has been instructed to apply to the Charge d'Affaires of the United States for such information as he possesses about the American claims that the government of the United States wish to have settled before recognizing our courts in Morocco. Mr. Blake's memorandum, under date of May 7th, sent in reply to our Charge d'Affaires compromises 14 claims, but 7 of these may be even now stricken out. The first 5, including the Betuli case, belong in Tangier, and the other 2 in El Khazar and Larache. They therefore do not come by reason of their suits under the jurisdiction of the protectorate and cannot be brought into discussion of relinquished extraterritorial rights in French zone. As of the 7 claims, they are all routine cases, and most of them are judicial in nature. They do not offer either their character or their importance a class of litigation which may afford ground for the United States for further postponing the relinquishment of extraterritorial jurisdiction and right and privileges. So they're basically saying all these cases don't really hit the source. All these cases don't show protection. They don't cross all T's and dot all I's. They don't say why you're still here, and they don't give proper instruction as to how you should get out, etc. So they answer a lot of questions, but they're not answering the right exact questions or pointing out the right exact things that need to be done. The resident general is, at any rate, even now making his duty to set a foot on examination of those cases and investigations by the protectorate local authorities respectively concerned therein. But these cases apparently are not such as to warrant opposition. As a matter of principle, the relinquishing of American extraterritorial rights, since the resident jurisdiction is now ready to examine and settle these cases in the most conciliatory manner, I deemed it expedient to relate here and above the explanations furnished by the Commissioner of the Republic, which answered every point in Mr. Bassett Moore's memorandum. These explanations meet every claim and objection of the federal government, both in satisfying inquiries bearing on specific points and in carrying promises to the minor points that could not yet be, but will be settled. Finally, the report throws all in full light, as it may be desired, some other topics that do not seem to have correctly understood or interpreted. The willingness of the federal government to recognize protectorate regulations powers cannot be doubted by the embassy or by the French government. I am convinced that Your Excellency will find the foregoing explanations all the palliations you may wish for, and I have no doubt that you will, as has already been done by most of the powers, agree to forego the benefits of extraterritoriality in the French zone of the Sharifian Empire and accept to place persons subject to American jurisdiction under that of our courts. So there you have again, the persons under the American jurisdiction are supposed to be under the French courts, right? Because they're the protectors, at least for this time being, right? Until we come in complete sovereignty, independence, stating why we should have such complete sovereignty and independence from point A to Z. So for this treaty to basically be null and void, what would we have to do? We would have to come online as more state governments and form another treaty, right? Canceling out that treaty as far as French being protected. Because why would we need a parent if we are calling ourselves governors of the land? Why would we need somebody to protect us in that sense, right? Now, for us to be acknowledged and be put in our rightful place, well, that's a part of this process of counterintelligence that everybody's playing, right? So it's not a step up, right? Everybody, we can't truly say, hey, France, you're wholeheartedly in this for the good, sincere, right? You're sincere about it. You can't wholeheartedly say this because look at the relationship we had with them, right? Up and down. So to say that they're in this to help us up and help us develop as a government, et cetera, in so many ways, yes, in so many ways. But we got to remember that even a lot of these treaties are not for European powers to develop Moroccan governments. It's not for that. It's to maintain peace between the two nations, between the several nations, right? Not for one government or one organization to come in and develop, your government when instructions are there and you're supposed to basically pick yourself up by the strap roots and be able to follow instructions and work with people who want to follow instructions. So that's pretty much that. But so as we read this last sentence or this paragraph, aware of the friendly and reciprocal good which will always preside over the settlement of such questions between our two countries, I cannot but remind once more in conclusion, Your Excellency. Right. So we can read this last little bit. The Secretary of State speaking to French, Charge d'Affaires. He says, Sir, I beg to acknowledge the receipt of your note, July 16th, in a reply of the Department under date February 13th, 1914, relative to the recognition of the government of the United States of the French Republic, French Protectorate in Morocco, and the desires of this government for the settlement of certain questions affecting American citizens and American protégés and their rights in that country. The American government has assured that the government of the French Republic of its favored disposition towards the reform of the French Protectorate proposes, and will give the remarks contained in your note referred to above careful consideration. France replied by saying, in continuation of the previous communications, that last being the letter of July 16th, last from the Charge d'Affaires of France relative to the claims of Morocco preferred by the federal government. Excuse me. Charge right quick. Use it. Okay, so it goes to say, claims in Morocco preferred by the federal government, which it thought had better be settled before extraterritorial rights were relinquished. I have the honor to inform Your Excellency that the result of the Okay. Just a second. Okay. Sorry about that. So it goes to say, um, I have the honor to inform Your Excellency that the result of the latest inquiries prescribed by my government concerning those claims has just been made known to me, and I deem it my duty to impart it to you as follows. First, in regard of the Worskell case, actually, kind of skip down to here. It says, second, in regard to the vacuum oil company's claim touching some land it purchased from the Ben Sauter, in which it is said that the Moorish authorities will not allow to be sold because the land being Habu property. The legation of the United States declared in memorandum of the case it cannot consider any settlement bearing on Habu property to be applicable to its citizens and proteges before the forms required by Article 63 of the Act of Algeciras have been complied with. But in the opinion of the government of the Republic, the treaties of 1880 and 1906, which is the Treaty of Madrid and Act of Algeciras, cannot bar the Sharifian government from amending or perfecting thereafter the laws and regulations existing at the time of the signature of those treaties. Article 63, cited by the legation of the United States, can hardly be invoked in the particular case. It deals with the examination of titles and Habu property occupied under certain conditions by foreigners in 1906. In the present case is that of land purchased in 1913 by the Vacuum Oil Company, upon which there seems to lie certain Habu rights. It can hardly be doubted under the circumstances that the case in the dispute is that of a land transaction, which if it does not partially or wholly concern the Habu administration, must be settled proper regard to the existing regulations governing Habu cases. So, just like with us, they're saying that if there's no Habu administration or Moorish administration, right, then it says it must be settled proper with regard to the existing regulations concerning Habu cases. So since we don't have a government in Habu administration, they didn't have a government, right? It's to be settled by the rights that's been aligned in treaties. So since we didn't have a government and ours was falling, France became the power of attorney or the protectorates over Moorish affairs, right? In 1912. And that's how things are supposed to be governed from that next standpoint. So exists the protectorate government has nevertheless asked the Habu Department to institute a thorough investigation of the case, and the legation of the United States has been so informed. As to the various other questions, most of them, very little account, loss of an ox in 1911, the Patil case, which can only be settled in accordance with the existing law. Theft, the existence of which is not admitted, supposed to be committed to the detriment of the American citizen, a money changer by trade, bearing the name Muhammad bin Ali, bags of sugar, 10 in number, lost at La Roche, that is to say the Spanish zone, etc. The acting agent, okay, I'm going to read that sentence over. As to the various other questions, most of them of very little account, the acting agent and consul general of France at Tangier has opened negotiations with the representative of the United States in that city with a view to reaching the earliest possible friendly settlement of a few questions. The government of the public would fain believe that on the strength of the foregoing statements, which, added to the previous submitted, are sufficient proof to the sincere readiness of the French authorities to bring without delay all these cases of legitimate termination, the government of the United States will kindly as to has repeatedly and lastly on July 24th last intimated intimated on the embassy make a favorable answer to the request. I have the honor to present as early as last year, and to the effect of the government of the United States agrees, it has already been done by several European governments, to the abrogation, so far as it concerns, of the capitulations of Morocco, wherever the government of the Republic has organized French courts. So that last sentence is important. It's important. And I'm gonna read it again, even though it's a long sentence. But it goes to say, I'm gonna start halfway through the paragraph. It says the government of the United States will kindly, as it has already repeatedly and lastly on July 24th, last intimated to the embassy, make a favorable answer to the request I had the honor to present as early as last year, to the effect on the government of the United States agrees, it has already been done by several European governments, to the abrogation, so far as it concerns, the capitulations in Morocco, wherever the government of the Republic has organized French courts. So what does this mean? Capitulation regime. What's capitulation? Right? Because that's what it's talking about. Capitulations in Morocco, wherever the government of the Republic has organized French courts. So let's look up this term capitulation regime right quick. Capitulation regime. Capitulation is a treaty or unilateral contract by which a sovereign state relinquishes jurisdiction within its borders over subjects of a foreign state. Okay. So a treaty or a unilateral contract, right? A unilateral contract. This is by way of force. United Nations forcefully telling United States of America what to do, right? Making this a one-sided thing. A unilateral contract by which a sovereign state relinquishes jurisdiction within the borders over the subjects of a foreign state. A foreign state. So the state doesn't die, right? The Moroccan Empire, it's just been dormant, right? It's just been asleep, put in a coma. It doesn't die. It's like saying a mental state or a spirit, like it dies in a certain fashion of something that's supposed to be lasting forever. So we got our government that was just basically ransacked. They didn't say, okay, we're shutting down. This is the law. We're shutting down the Moroccan Empire. All it's over with. It never went that way. By way of colonization, unlawful acts is the only reason we became dormant. So being that it's still there, we just had to fill our seats. It wasn't dead. The state is still there. That foreign state. So if United States is a foreign state or a foreign government, right? If they're the foreign government that relinquish jurisdiction, consular court jurisdiction over a foreign state, then that means there's still work to do as far as exercising human rights. Because just because they got rid of consular court jurisdiction, don't mean that they got rid of all jurisdiction. No, they still have what's called capitulation regime, right? Because what happened? Jurisdiction was relinquished, but there's still certain things that they're able to do, as we're about to read. So criminal and civil law was relinquished. Consular jurisdiction, right? Relinquished. But again, that wasn't all jurisdiction, because if they previously expressed, these foreign powers can only do so much, right? So okay. So these last few paragraphs, the charge d'affaires to the Secretary of State. British charge d'affaires informs that owing to Turkish intervention in European war, British government has proclaimed a protectorate over Egypt. A full agreement having been rapidly reached between France, Spain, and Great Britain concerning the international regime of Tangier, Great Britain consents to recognize the French protectorate in Morocco in exchange for recognition of British protection in Egypt. British legation here will be immediately suppressed by the British charge d'affaires will be appointed diplomatic agent and consular general. The question of the suppression of the capitulations in the two countries is reserved for ulterior discussions and forms no part of the present misunderstanding. Italian, Spanish, and our own are the only legation remaining. It is possible that the international statutes of Tangier may shortly be presented for the consideration of powers, but their application will likely be deferred until the ending of war, as otherwise the international character of the community will entitle the expelled representatives of Germany and Austria-Hungary to recognize technicalities. In exchange for compensations elsewhere, all the powers with exception of the United States have now recognized the French protectorate. I see no reason why we should depart for the position that the recognition of the French protectorate and the suppression of the American legation must be deferred until the settlement of our outstanding cases has been discussed. This point of view is well understood and seems to be admitted by the French local authorities as being both logical and reasonable. So that concludes the letters between the two governments, right? In which those were just the letters. That wasn't the actual case, which we'll get into next. Not the whole thing. It's a 40-page something document, but I'll highlight the important parts to where it talks more about capitulation regime, because they just mentioned it in these letters. It talks, more about the dominions and the reality of that when in the actual France versus United States of America case. So just to give a quick overview before we open up Q&A, these letters between France and United States, 1912 through 1914, these letters called out the beginning of things. Because in the 1950s, we obviously have France taking the United States of America to court. So obviously, throughout those decades, in between time, something wasn't done. Something was repeatedly being ignored, etc. So France took them to court, right? In which we now have further instructions put on the line, because when they was writing those letters, they was just putting it on the record. It wasn't too much of a, I'm going to give full detail of where you're wrong, etc., etc. You know, like it is in court, where you have to cross all T's, dot all I's, right? So again, we'll get more into understanding our instructions. You know, some Moors like to study the Topaf, or the Treaty of Peace and Friendship, and go based off of certain articles off of that, when we can read the France versus United States of America case and see other articles and other Moorish treaties that are more important in regards to our earthly salvation, right? So as you can see in those letters, it mentioned, you know, us getting land back, all that type of stuff, all in the active outer series, which we'll go over again, um, etc. So even though some of this information seems redundant, it's very important to brush this dust of misinformation off of our minds, because that's really what this is all about. So with that being said, I open the floor up for Q&A, any comments, concerns, etc. And with that, I yield the floor. No questions, comments, concerns? Okay, so we can conclude the meeting with that. Well, as far as that point, before we conclude this whole thing, well, let me actually end this video.